A very warm welcome to everyone who is joining us today for the IUCN World Commission on Environmental Law webinar, From Authoritative to Operational: How the BBNJ Agreement Can Implement the Climate Change Advisory Opinions. My name is Christina Voigt, and I'm the chair of the World Commission on Environmental Law and a professor of law at the University of Oslo. This webinar today is part of the IUCN World Commission on Environmental Law's webinar series titled The Transformative Power of Law: Addressing Global Environmental Challenges, where we seek to discuss new developments in international environmental law. Like all our webinars, also this webinar is being recorded and can be accessed on our website at the IUCN main website. With this webinar today, we celebrate the entry into force of the BBNJ agreement on the 17th of January this year. The agreement has currently 84 parties and is a testament that multilateral solutions not only are desirable, but possible. And with this webinar today, we also commemorate the life and work of WCL member Christina Gjerde, who untimely passed away in December last year. The BBNJ agreement was Christina's life, work, passion, and her legacy. Several international courts rendered advisory opinions on climate change in only the last 3 years, and IUCN, represented to the World Commission on Environmental Law, participated in all these proceedings with written and oral statements. In particular, the International Tribunal on Law of the Sea in 2024 and the International Court of Justice in 2025, in their respective advisory opinions on climate change, commented on the BBNJ agreement. The International Tribunal on Law of the Sea noted in particular the provisions on environmental impact assessment in the BBNJ agreement as relevant for assessing the specific and cumulative effects of planned and other activities on the marine environment in the context of climate change impacts. Importantly, it noted that in the context of greenhouse gas emissions, not only planned activities may be environmentally significant if taken in isolation, but may produce significant effects if evaluated in interactions with other activities and in a cumulative manner. The ICJ highlighted in particular the provisions in the BBNJ agreement relating to the establishment of area-based management tools, in particular marine protected areas, and referred in general to the ITLOS advisory opinions. It is therefore timely and opportune to move from these authoritative statements and authoritative classifications to what it means in practice in the implementation of the BBNJ agreement. It is therefore my great pleasure to pass the floor to the moderator of today's webinar, Professor Cymie Payne, who not only is the chair of the IUCN World Commission on Environmental Law's Ocean Law Specialist Group, but she also represented IUCN in the BBNJ negotiations, as well as before the International Tribunal on the Law of the Sea on several occasions. She also is the recipient of the 2025 IUCN-WCEL Nicholas Robinson Award in Excellence in Environmental Law and Policy. Dear Cymie, I'm very happy to pass the floor on to you.
Christina, thank you so much for introducing our webinar and for your leadership. And I think it's timely also to congratulate you on your new term as the chair of the World Commission on Environmental Law. So we're very pleased about that outcome. And as I think I'll first introduce our speakers, and I'm going to start with Nick Robinson because you now, knowing that an award is named after him, you will realize that he has been such an important force in international environmental law, being not only the legal advisor to the International Union for Conservation of Nature and the chair of the World Commission on Environmental Law for a period, the creator of and convener of many, many important international environmental law bodies, papers, events, the list goes on. And he is now the Emeritus Chair of WCEL and an Emeritus Professor at the Elisabeth Haub School of Law at Pace University. Now I'm going to flip back to alphabetical order and introduce Tara Davenport, who comes to us from Singapore. She's an assistant professor at the Faculty of Law at the National University of Singapore, deputy director of the Asia Pacific Center for Environmental Law, and co-head of the Ocean Law and Policy Center for International Law, all at the National University of Singapore. Tara was a key member of the IUCN team that responded to the request from the Law of the Sea Tribunal that IUCN provide a submission for the climate change advisory opinion that it issued. Next, I'll turn to Claudia de Windt. Claudia is a member of the steering committee for the IUCN World Commission on Environmental Law. She's a distinguished professor and practitioner of international law, and is the CEO of the Inter-American Institute of Justice and Sustainability. And Claudia led the effort for IUCN's submission to the Inter-American Court of Human Rights climate change opinion. Next, Duncan Pickard is an associate of in the Public International Law Group at Debevoise in Plimpton. And we ran into each other, I think, in Hamburg at the International Tribunal for the Law of the Sea. He'll be speaking to the ICJ opinion today, which he also worked on. So we have a sterling lineup here, and I don't want to take any significant more time, but I wanted to just have a couple of words here. Oh, I guess so. Just so the audience knows, we'll first have a conversation amongst the speakers, and then we'll have a few minutes for Q&A, not too much, but perhaps if you have questions, you can put them in the chat. And if we can respond online, we will, and we'll try to reach your questions. Let's see. So, just to comment on the time, Christina gave you a good background for the major landmarks and the progress of why we're here. But it's useful to know that now that the BBNJ agreement has entered into force, it's gotten sufficient ratifications for that purpose. Got 60 ratifications by September 20 of last year. Now, it's critically important to undertake all of the steps to put the institutions and processes in place. The first conference of the parties has to take place within a year of January 17th, 2026. And that may happen as soon as August. It might be a little later this year, or it might even be next January. And there is much to ready for that. So here we have the advisory opinions that both have large principles, large statements made, but it's up to us now to figure out how to implement them. And we have a new treaty that we need to interpret in the light of other international law. So this is really going to be our focus today. And to start out, I'm just going to ask each speaker, what was your relationship to the advisory opinion that you're speaking to? and ask you each to provide a brief comment on the advisory opinion, how it approached climate change impacts on the ocean and greenhouse gas emissions from ocean activities. And this is a real challenge because I'm going to ask you to be very brief. And they're very long, complex opinions. And I think it makes sense. Let's take it in the order of when the opinions came out. So that would be Tara, Claudia, and Duncan. So.
My apologies. I'm having some technical issues. Thank you very much, Cymie, for that introduction. And thank you very much to Christina and Cymie and Roberto for organizing this. I had the privilege of being part of the IUCN team that made submissions to ITLOS and was very grateful to be part of an amazing team of law of the sea and climate change experts and scientists. And I learned so much, not only about substantive matters, but about crafting legal arguments and advocacy. I think I will. I think that the ITLOS advisory opinion is a long opinion and is very comprehensive. I think I wanted to focus on maybe 3 or 4 points. Firstly, I think the issue that COSIS had asked the ITLOS to decide was generally what were the current legal obligations of state parties under UNCLOS in relation to the impact of climate change and the marine environment. And I think the first point that ITLOS found was that greenhouse gas emissions are marine pollution. And I think that this is something that we spent a lot of time on during the submissions because I think the issue was that the Law of the Sea Convention was negotiated at a time when climate change was, not a big deal. It was not envisaged as a huge problem. And therefore, there's no mention of climate change in the Law of the Sea Convention. And that's why it was very important to have this idea of greenhouse gas emissions being pollution or constituting pollution of the marine environment. And definitely ITLOS determined that greenhouse gas emissions do satisfy the definition in Article 1, paragraph 1(4), because they are substances and energy introduced by humans that result in deleterious effects like ocean warming, sea level rise, and ocean acidification. And this triggered the extensive obligations found in Part 12 of UNCLOS, which requires states to prevent, reduce, and control marine pollution. The second aspect of ITLOS's advisory opinion was on the obligations to prevent, reduce, and control pollution from GHG emissions. And again, UNCLOS is quite comprehensive. It has very both general and specific obligations. And as long as the word pollution included GHG emissions, this would apply to place obligations on states to prevent, reduce, and control pollution from all sources, including GHG emissions. Under this particular heading, I think there are 2 points I wanted to emphasize, which is the obligation of due diligence. Right? The tribunal clarified that the obligation to prevent marine pollution from GHG emissions was an obligation of conduct rather than an obligation of result. The tribunal built upon previous advisory opinions, which elaborated on the nature of the due diligence obligations and found that it imposed a stringent standard. And this is because, of course, climate change poses a high risk of serious and irreversible harm to the marine environment. And the tribunal ruled that the standard of due diligence is stringent, but recognizing that the implementation of due diligence may vary according to states' capabilities and available resources. The other point I wanted to emphasize was the tribunal very notably elaborated on how international rules and standards set out in the UNFCCC and the Paris Agreement were relevant in determining the necessary measures that states must take to prevent, reduce, and control pollution from GHG emissions. And again, this has broad implications for the systemic integration of other international obligations within the UNCLOS rubric. And the tribunal found that the UNFCCC and the Paris Agreement, as a primary legal instruments addressing climate change, were relevant in interpreting and applying the convention with respect to marine pollution, and in particular, the temperature goal and the timeline for emission pathways, which inform the content of necessary measures to be taken under Article 194, paragraph 1 of UNCLOS. However, I think this is also key. While the Paris Agreement and the best available science, specifically IPCC reports, inform measures a state must take, compliance with the Paris Agreement alone does not necessarily satisfy a state's obligations under UNCLOS. States are required to take all necessary measures to achieve global temperature, the global temperature goal of limiting the increase to 1.5 degrees above pre-industrial levels. And I think the last point, I mean, there's so much, it's a very rich opinion, and there's so much to talk about. I think the last point I wanted to maybe touch upon, which is the obligation to protect and preserve the marine environment, which was the second question posed by COSIS. And ITLOS found that under Article 192, states have a broad mandatory duty to protect and preserve the marine environment from climate change impacts. And this includes ecosystem restoration, specific measures to protect rare and fragile ecosystems from the impact of ocean warming and ocean acidification. Coastal and fishing states have to use a precautionary approach, an ecosystem approach to manage fish stocks that are threatened or shifting due to climate change. And the tribunal also noted the importance of the use of area-based management tools, including marine protected areas, to strengthen ecosystem resilience. I think, I know that's a very brief summary and probably does not do justice to it, but I think we have a lot to go through, so I'll stop there.
Thank you, Tara. That was great. And I think it shows how ITLOS lays the groundwork for what's to come. So, Claudia.
Thank you, Cymie. Good morning, and thank you for organizing this and to everybody. This is a very special topic to me. Being from an island, you can't ever run away from the ocean. So great to be here. So I was fortunate to participate and lead the effort to the Inter-American Court on Human Rights, working with an amazing team of WCL members from across the region, and to have the fortunate companionship and leadership of Christina in the process. I also participated in the ICJ process in a different capacity, but the Inter-American Court proceedings are the focus of our conversation today. So I will not do justice to the opinion because it's more than 300 pages and there is so much richness in the work of the court. But I do want to highlight a couple of things for our conversation today. First, we have to remember that this is a human rights court. It's a specialized court. So the main obligations that are addressed by the opinion have to do with the respect and the guarantee of human rights and how that connects to the protection of the marine environment in the context of oceans, what we're talking part and part 12. And why do I say this? Because the court uses a systemic approach to addressing ocean degradation as a consequence of climate change. So it talks about, in the opinion, ocean acidification, warming, deoxygenation, and sea level rise as consequences that result in harms that can materialize for people. And this harm can be cumulative, it can be systemic, as I've already mentioned, and it can also be transboundary. The court doesn't single out ocean emissions that come from oceans activities, but it does address the consequences throughout the economy of greenhouse emissions, and it separates by area. So, for instance, we have some discussion in the opinion of the percentage that has to do with transportation and the marine economy. So, in that, what I do want to mention here is that the key of the obligations are, first of all, going to the human rights aspect, substantive and procedural rights that need to be protected. So the main aspect that relates to BBNJ and to oceans has to do with preventing that harm that I addressed. And there on climate mitigation, we have the due diligence obligation, which was also mentioned by Tara in the context of ITLOS. And as part of that obligation, we have the duty to conduct environmental impact assessment. In the context of the EIA, it's not just the court indicates clearly that you have to distinguish the climate impacts from environmental harm overall. You have some provisions that are in BBNJ that have to do with a cumulative impact, but a value added from the opinion of the Inter-American Court is that it specifies that conducting EIAs is considered a safeguard for environmental and social rights impacts that projects can have on the marine marine environment. Additionally, when we go to the obligations with regards to adaptation and the human rights-based approach on adaptation, there's a requirement to conduct an assessment of all adaptation measures. So some activities related to cooperations may be related to adaptation. And when it comes to adaptation, the focus there is to conduct a human rights assessment as well as part of the EIA. So those are some of the novelties that we see in the opinion of the court. But there is, of course, more when we go to addressing the best available science, traditional knowledge, and some of the other obligations that we're going to discuss further in the webinar.
Thank you, Claudia. That was really useful. And perhaps I should make a quick sketch for those who are familiar with the advisory opinions, but not so much with the BBNJ agreement, that this agreement deals with marine areas beyond national jurisdiction. So everything beyond the 200 nautical mile EEZ and excluding the seabed where there's an extended continental shelf. But that's a vast area of the ocean. It's a vast area of the planet. And there are four key elements to the BBNJ agreement. One deals with fair and equitable sharing of the benefits of marine genetic resources. Then there are two that are critical to our discussion: the area-based management tools, including marine protected areas. It creates the possibility of establishing those. And so this is where what Tara and Claudia have mentioned fits into the kind of protect and preserve the marine environment element. And then the third element is the environmental impact assessment, which Claudia has just been discussing. It provides an obligation and a process. And also the BBNJ agreement specifically mentions a number of the elements that Claudia just referred to, including taking climate change into account, cumulative impacts, and there's also a focus on the inclusion of traditional knowledge and a fairly broad stakeholder group in that. So thank you for that. Duncan, turning to you, you have the floor.
Great, thank you. Thank you so much. Really thrilled to be here. I was honored to be on the council team at the ICJ for Tuvalu, COSIS, and the World Health Organization, and also similarly on a team for COSIS at IDLOS, the Inter-American Court. This was a really amazing couple of years to be working on these issues. So addressing the ICJ in particular, the ICJ, their focus, building off of the request from the General Assembly, was really on the global climate system. The court obviously made the point that the ocean is integral to the global climate system, but beyond that, didn't go into too much detail on the ocean specifically or expressly. And I think that was a demonstration of institutional constraint on the part of the court. They knew that they were setting out general principles for international environmental law related to climate change, and wanted to leave some sector-specific rules and principles to be elaborated further. And I think that highlights why instruments like the BBNJ agreement are so important, because the ICJ was setting out general principles, but they really need to be implemented in much more detail. So just going to start briefly by addressing what the court did say expressly about the ocean, and then I want to talk a bit about some of the general principles that the court elaborated that I think are particularly relevant for the BBNJ agreement. So starting what they did say about the ocean, they of course took as a starting point affirming the famous statement in the Nuclear Weapons Advisory Opinion, saying that states must ensure that activities within their jurisdiction respect the environment of other states and also areas beyond national control, which includes the global ocean. The court also expressly affirmed the core conclusions that of IDLOS that Tara laid out, including states' obligations under Part 12 of UNCLOS, and in particular the court's findings under the tribunal's findings under Articles 192 and 194. Quite importantly, in the section on legal consequences, the court also held expressly, I'm quoting here, that because all states have a common interest in the protection of global environmental commons, like the atmosphere and the high seas, unquote, that states' obligations to protect the environment from GHG emissions are owed erga omnes. And I think that this sort of subtly reinforces that harm to the ocean commons is legally cognizable, even absent individualized inquiry. It's quite an important statement from the court. And then the court also had very important statements on sea level rise, including affirming that states don't have an obligation to update their baselines, notwithstanding physical changes to the coastline. And that has the effect of fixing what we currently conceive of as the high seas. There was, as Christina mentioned, the court very briefly mentioned the BBNJ agreement. They primarily noted that a number of participants had invoked the BBNJ agreement in their submissions. The BBNJ agreement was also in the dossier of documents that the UN Secretary General provided to the court. The court was pretty brief. They just addressed the BBNJ agreement in one paragraph. They noted that the BBNJ agreement had been signed and not entered into force. They did note that the BBNJ agreement included the establishment of area-based management tools, and they said that the entry into force, or the signature of the agreement, triggered states' obligations under Article 18 of the VCLT, but didn't really go beyond that. And I think maybe we'll turn to this later. I think it's an interesting thought experiment to tease out what the court may have done if the agreement had entered into force before the opinion. I just want to turn briefly to three general themes that the court addressed that I think are reflected well in the three mechanisms that Cymie mentioned are integral to the BBNJ agreement. The first is that the court really emphasized the importance of environmental impact assessment as part of states' due diligence, stringent due diligence obligations to prevent transboundary harm. The court expressly noted that states have to account for cumulative impacts in their EIAs, which is a theme running throughout the BBNJ agreement. And they also noted obligations of notification and consultation of the EIA, which is, Cymie didn't mention the clearinghouse mechanism that is important in the BBNJ agreement that cuts across those three themes that she did mention, but I think the clearinghouse mechanism is a clear example of how of a tool that can implement these notification consultation obligations. The second principle to mention briefly is that the ICJ expressly noted what they call the principle of sustainable development as relevant to climate change, and I think this is very well set out or well implemented in the area-based management tools that are in the BBNJ and sustainable use of marine resources in those areas. That's a critical part of the proposals and approvals of marine protected areas. And then finally, and I'll close here, is the court's endorsement of the principle of equity as important in interpreting states' climate change obligations. And one way that this comes into practice through the BBNJ is in provisions relating to marine genetic resources, which have, I think, very important climate intersections. Just to mention one example of that is research that's being done into resilient reef organisms that can withstand heat and increasing ocean acidification, including corals. And it's very important that research being done into marine resources that can withstand changes to the ocean be shared equitably across the world. So I will stop there.
Wonderful. Thank you so much, Duncan. So I think what you've heard now is from all the speakers, the importance of environmental impact assessment with the preparatory commission meetings in March and April for the BBNJ agreement. The clearinghouse mechanism will be an important element of what is discussed. Standing that up, making it an appropriate and effective tool, the groundwork is being laid for that. If you go to the Division of Ocean and Law of the Sea, so it's DOALOS, D-O, someone put it in the chat, please. There's a link to, they have a BB&J website, and you can find the documents, you can find some materials about the clearinghouse mechanism, as well as other documents about more institutional issues that'll be discussed in the end of March, beginning of April. The other thing about the EIA element and the entire treaty is at this point, many states that ratified the treaty didn't have their legislation in place beforehand. And so they're working on national legislation. And what they include under the environmental impact assessment obligation, as they understand it, will be critical for the implementation of the treaty. So this is not just an international facing issue, but it's a national facing issue. So if a country excludes shipping from its understanding of its EIA obligation, that leaves a huge gap that was not, in my view, intentional during the negotiation. So that's another area to bear in mind. I think you heard a little bit about the interest of each of the courts in science and beginning their opinions talking about the science and the Intergovernmental Panel on Climate Change. We were going to discuss that more, but I think in the interests of time, I would like to turn to some specific questions. You can simply note that the IPCC was considered the benchmark for the science in this case, and that these courts built their opinions on the best available science. Claudia, could you tell us, so the BBNJ addresses some of the obligations identified by the courts, I've just noted some, but also the interpretation of the court can shed light on some of the BBNJ provisions. Could you unpack that for us, please?
Thank you, Cymie. So it's a very interesting question, and I think it connects a little bit to the science piece. So I'll delve a little bit more into what the court said about science in answering this question. So the first thing is that as part of that systemic integration approach, the court built on its past interpretation of human rights not occurring in a vacuum and obligations occurring in the context of a multilateral system of environmental conventionality. So this brings the BBNJ provisions into play and makes a lot of the findings of the court applicable when you're to implement the BBNJ agreement. As part of the duty to prevent harm to the environment and the marine environment in this case, the court was very specific about the protection of carbon sinks. So in this context, it says that countries don't only have to limit emissions within their jurisdiction, but they also have to cooperate to protect those carbon sinks. And this is what brings me to science, because there were three areas in which the court put emphasis with regards to science. One was the best available science that we have already discussed, but there the court, in addition to ratifying that IPCC is the best available science and that evidence really leaves no room for indifference when it comes to due diligence in this in the protection of the marine environment and prevention of harm, it talked about ensuring that the evolution of laws is in accordance with the best available science. So in that regards, you're mentioning that there are a lot of countries that are going to be working on legal reform and adapting their norms to support implementation of BBNJ. So taking that into consideration is important. The other aspect has to do with scientific cooperation as part of the duty to cooperate. So here the court built on some of the instruments of the Inter-American system, like the OAS Charter, and discussed how the welfare and the progress of the people of the Americas increasingly require cooperation, and detailed clearly what that cooperation means. And this is very applicable to the provisions on cooperation that we have in BBNJ. So for example, cooperation, the duty to cooperate should include financial and economic aid to least developed countries, technical and scientific cooperation involving communication and common enjoyment of benefits of progress. So this goes to the genetic material and the marine resources, implementation of mitigation, adaptation, and reparation actions that can benefit other states, and the establishment of activities that are specific, that generate well-being. And then the final thing here has to do with traditional knowledge and the right to science. On the right to science, sharing scientific progress and information among states, and it emphasized that traditional knowledge can coexist with other types of scientific developments. So I think that that's one of the cooperation, and on the EIA, those are the two areas where I see the most synergies amongst the interpretation of the Inter-American Court and what we have on BBNJ, especially considering the role of science in identifying the risk, in particular where it has to do with the role of private enterprises, for example, as part of the duty to mitigate.
Thank you. That is really interesting, taking us deeper into the opinion, starting to help us find our way around it. So Tara, could you reflect on the systemic integration of the BBNJ agreement and sort of share with us your thoughts about those interactions?
Okay, thank you so much, Cymie. I think I want to make three very brief points. First, I wanted to say that both the BBNJ agreement and the advisory opinion are excellent examples of UNCLOS's continuing relevance as a living instrument, right, capable of adapting and evolving. I think it's especially remarkable that neither climate change nor marine biodiversity was explicitly mentioned in UNCLOS. It was not a concern during negotiations, but UNCLOS provisions have been interpreted to directly place obligations on states relating to climate change, and has also provided the foundation for states to negotiate a new implementing agreement. Second, and I probably should have mentioned in this my first remarks, my first section of remarks, which is the impact that the negotiations of the BBNJ agreement has had on the advisory opinion of proceedings, right? And I think it's very important to remember that both the BBNJ agreement and the advisory opinion emphasize the link between climate change and marine biodiversity, and how climate change impacts marine biodiversity, right? And how loss of marine biodiversity exacerbates the ability of the oceans to act as a carbon sink. If you look at the BBNJ agreement, it mentions, several times climate change, affirms the importance of ecosystem resilience, including the adverse effects of climate change. The EIA provisions require states to take into consideration cumulative impacts, including the impacts of climate change. And I think it's important to also mention that actually in the IUCN submissions, we had actually placed a lot of emphasis on the BBNJ agreement, right? I think, Cymie, you drafted that part. And it was, we argued that the text had special force and relevance to the question of the protection and preservation of the marine environment, even though it had not come into force yet. And we used it to strengthen the applicability of certain obligations and principles in relation to climate change, such as the precautionary principle, ABMTs as tools for ecosystem resilience. And we also argued that the BBNJ agreement reflected state practice and opinio juris on applicable EIA standards. Now, the advisory opinion only referred to the BBNJ agreement 2 times in relation to the EIAs. In relation to cumulative impacts, it said this is where the tribunal explicitly noted that the BBNJ agreement contained detailed provisions of EIAs. The tribunal also noted that the ABMTs, including marine protected areas, was a realistic response strategy to climate change, and also specifically referred to the BBNJ's use of ABMT. So I think, like Duncan, there was, we placed a lot of emphasis on the BBNJ agreement. They did not explicitly refer to it. Elaborate on it, but I think it was always in the background, right? I think it was very important, and it infused the judges when they were deliberating. The last point I wanted to say very briefly was, we have these 2 milestone achievements, right? The BBNJ agreement, the advisory opinion, all emphasizing, marine environment, climate change, marine biodiversity, right? And how is this going to impact on another regime, right? Which is Part 11 governing activities in the area, deep seabed mining, of course. This was, negotiated since the 1960s, maybe 1970s. And it's interesting to see how this is going to impact an older regime with its own specific interests and epistemic community, particularly when there is such a tension now on whether there should be a moratorium on deep seabed mining. And I think that we can see that there are sort of both invisible and visible impacts on the negotiation of the exploitation regulations at the moment. And if you look at the latest draft of the exploitation regulations, you will actually see provisions mentioning not the climate change advisory opinion, but climate change for sure, and definitely the BBNJ agreement, right? Talking about the importance of having a provision on cooperation, not undermining, even with the area-based management tools. I can see that slowly and in an evolutionary way, the ISA has been compelled to strengthen its BBNJ, its area-based management tools processes, right? And I think this is implicitly or indirectly in response to trying to match what the BBNJ agreement states. So I think that's very briefly what I wanted to say.
Great. Thank you, Todd. Yeah. Duncan, turning to you, following from the ICJ's and the ITLOS's approach to systemic integration, how should the BBNJ agreement's obligations be taken into account with respect to those in existing climate-related instruments? And the floor is yours.
Great, thank you. Just before addressing systemic integration, I just want to say very briefly about science and knowledge sharing, because I think it was a really important focus of the ICJ and also a really important focus of the BBNJ agreement. So the ICJ has a really nice paragraph 285, where they talk about the state's obligations to pursue technical cooperation and knowledge sharing initiatives. And how important knowledge sharing is to both adaptation and mitigation measures, and how facilitating this knowledge transfer can help states improve their EIA and due diligence compliance with their EIA and due diligence obligations. And I just want to highlight again the cooperation mechanisms under the BBNJ agreement, especially the clearinghouse mechanism. That is just a perfect example of how that type of important obligation can be implemented. So turning to systemic integration, ITLOS and the ICJ took slightly different approaches to systemic integration. I think based on the nature of the questions presented to them and their own mandates, ITLOS's approach was really about finding commonalities between clear scientific understandings and mapping those onto the Paris Agreement within the context of UNCLOS's obligations. And that, led to their key findings regarding mitigation obligations tied to the 1.5 degree Celsius temperature limit, and also adaptation, sort of science-backed adaptation obligations. The BBNJ was a bit of an asterisk to that, I'd say, as Tara mentioned. The tribunal did mention the BBNJ agreement several times. I think in that context, it's important to note, of course, that the BBNJ agreement is technically an implementation agreement of UNCLOS, and I think the IDLOS was very much aware of that, and left some of the obligations within UNCLOS to be kind of sorted out in the BBNJ agreement. The ICJ was a little bit different, I think, because they had so many different sources of law to interpret, given the broad question that was referred to them by the General Assembly. They began with what they called the climate change treaties, moved to customary international law, human rights law. I mean, it's just a really diverse set of international law obligations. And so the court really started with by endorsing the general principle that to quote the court, when several rules bear on a single issue, they should, to the extent possible, be interpreted so as to give rise to a single set of compatible obligations. Then the court there cited Article 31.3c of the Vienna Convention on the Law of Treaties. The court doesn't actually use the term systemic integration, but I think that's absolutely the approach that they were trying to take. And it really kind of marks a shift in the way that the court was talking about Article 31.3c of the VCLT. Another prominent example where they did this was in pulp mills, in an environmental law context. But there they were really invoking Article 31.3c to confirm that the obligations under the 1975 statute at issue in that case were consistent with customary international law. Where here, the court is really looking at the broad body of customary international law and treaty law and trying to come up with a common set of obligations. And I think it's obvious that that if the BBNJ agreement had been in force at the time of the advisory opinion, that it would have been one of the sources of law that they would have considered relevant and baked into that broader systemic approach. I've already mentioned some principles that are clearly consistent with obligations set out in the BBNJ agreement. I want to note, though, a potential source of tension that would have been interesting to see play out if the agreement had been in force at the time, and this relates to the polluter pays principle. That is set out in the Rio Declaration and is sort of what was the focus of a lot of submissions before the ICJ. The ICJ actually expressly wrote, this is at paragraph 160, that the polluter pays principle is not envisioned or reflected in any of the climate change treaties, nor has it been accepted that this principle applies directly in the relations between states without having been specified in a treaty. So they found that it was not part of general customary international law and was not reflected in the climate change treaties. It is reflected in the BBNJ agreement at Article 7A, and elsewhere throughout the agreement. So I think it is interesting, to think about what would have been if the agreement had just come in force a few months earlier.
Fascinating. That's one of the things that you've highlighted is that cooperation is one of the through lines on all of these. And the BBNJ agreement does something special, which is that it creates a conference of the parties under the UN Convention on the Law of the Sea, which doesn't have a conference of the parties of its own, which helps in doing some of these cooperative activities. I'd like to turn now to Nick Robinson And Nick, ask you to kind of sum up for us, what do these bold statements of international law and the multilateralism that is embedded in the coming into force of the BBNJ agreement, what does that portend for us in 2026 and beyond?
Well, thank you very much, Cymie. And I want to thank Tara and Claudia and Duncan and you for these wonderful explanations of the advisory opinions. They really do chart the way forward, not just in the meetings in March and 2026, but as far as we can see into the future. It's an extraordinary foundation for the progressive development of international law. I'd like to highlight the comparative law aspects which haven't been mentioned yet. Practically every state has already adopted national legislation on environmental impact assessment. There are procedures in place, there are civil servants in place, there's judicial review in place. And so, although EIA is very unevenly implemented around the world, and in my humble opinion, not very satisfactorily implemented, the basis is there already in law for the activation of the BBNJ in terms of national EIA procedures. There's also a substantial amount of national law on protected areas, which can and already is being applied to marine protected areas in the territorial and exclusive economic zones. And this provides a basis for then guiding what will happen when states look at shaping the area-based management tools and including the MPAs. So I think we have a fundamental basis already in place to implement and activate through these practical tools many aspects of the BBNJ agreement. And I would urge us to take a look at how national law can further and rapidly further the BBNJ. Globally, I think the theme that runs through all of these very careful legal analyses that we've just heard is that climate change is progressing. It's happening and it's accelerating. And we need to get a handle on maintaining the ecological integrity of the oceans during that time and cooperating together on how to do that. So there's urgency in the meeting next March in New York. There's urgency in the implementation and activation of the tools that BBNJ provides. And I think I'll leave it at that due diligence requires EIA as a demonstration that we are in fact observing our international obligations under treaties, under customary law, and under the general principles of international law.
Thank you so much, Nick. That's wonderful summation. We have a few questions in the Q&A, and perhaps I know there's one that's directed specifically to you, Duncan, asking what would be the role of landlocked countries in relation to the BBNJ jurisdiction, and how would equity apply to these countries? And perhaps you can respond to that sort of in light of the advisory opinions, if that's not fair to do.
Sure, absolutely. Yeah, I think I'll just answer that briefly, given that we have a lot of questions and not much time. Landlocked countries are absolutely, as equal as anyone else, as coastal states in the equity principles under general international law, UNCLOS, and the BBNJ agreement. We didn't talk too much about sort of equitable sharing of benefits from marine resources, commonly held marine resources. Of course, some of those benefits, like heat and acidification tolerant organisms that I mentioned earlier, would be less relevant to landlocked states, but sort of equal sharing of benefits from common resources applies equally in principle to all states.
Thanks. I'm going to invite, we have quite a few questions, and so I'm going to invite the panelists to take a look at the questions there, decide which ones, given we have 6 minutes left, 5 minutes left, maybe choose the ones that you would like to answer. And I think I'll go through in the order, our initial order, and invite you to respond, and if you want to include a closing remark. So Tara, over to you.
All the questions are very difficult. Great questions, but very difficult. And I have to confess that I don't know the answers to many of them. And I mean, the first question on the history of flip-flops by major economies, such as the US withdrawal, and accountability. And I think the fourth question about when the USA disregards BBNJ agreement and DSM negotiations, right? I think it is a fundamental problem that we are facing at the moment, and it's also because the US does fund a lot of these institutions. So that is, I think the withdrawal of funding in particular is going to be impactful. I have no answers to this, and I would actually turn it back to both Christina and Cymie to maybe answer this, or the rest of the panelists. But I will say that, I think that international law is very much about communication. It's a common language. It is about leverage, right? If we didn't have international law, we've got to, the people who care about international law, we've got to keep on talking about it, talking about why it matters, communicating why a particular action is contrary to international law. And, the hope is that all this will nudge slowly and incrementally states, get states and, relevant stakeholders to understand why international law is important. And I think I will end there.
Thank you. Claudia.
Thank you, Cymie. I think that the questions are very difficult, so I will just use a few seconds to say that I think we are in the era of international law. The principles are out there. In the case of the advisory opinion of the Inter-American Court, I think that the coherence between the progressive development of human rights, preventing environmental harm and harm to the climate system, and the complementary application of the pro-nature and the pro-person principles are there. What we have in the current geopolitical context that we are experiencing has to do with the rule of law and with respect to the rule of law. And that's where each and one of us has an important role to play in seeing that in our work, we're able to continue advancing what the courts have put out there, the tools that they have given us to solve the problems that we're facing today.
Thank you. Duncan.
Great. Thank you so much. I'll briefly address 2 questions. They're all great, but just in the interest of time. One is on IFBs and whether the courts could be considered IFBs for BBNJ purposes. I don't think so, but it gets to a larger issue, which is how can we sort of engage with the advisory opinions in the implementation process for the BBNJ agreement. I think organizations like IUCN play a critical role in doing that. And also there is a mechanism in the BBNJ agreement for the Conference of the Parties to request an advisory opinion from IDLOS on its obligations. So there are sort of formal and informal follow-up mechanisms, even if the courts themselves wouldn't be considered IFBs. And then there's a very good question about whether establishment of marine protected areas could be misused, against the spirit of the BBNJ agreement to create an opportunity for states to exploit those areas. I think that is a very real risk, but there are mechanisms in the BBNJ agreement to prevent that from happening, including continued oversight by scientific bodies established by the agreement, by the Conference of the Parties. And there are, and I think also the dispute resolution clauses under UNCLOS that apply equally to the BBNJ agreement could be used to great effect in this case. And I would just make a brief reference in that respect to the court's the ICJ's judgment in the whaling in the Arctic case, where the court found Japan in violation of obligations to prevent whaling that were kind of dressed up as marine scientific research activities. And so, there are judicial mechanisms for scrutinizing misuse of these types of treaty-based mechanisms.
Well, I'd just like to extend my thanks and the thanks of the Ocean Law Specialist Group to all of you for wonderful, insightful comments. I'd like to express my appreciation to the audience for participating and for joining in the World Commission on Environmental Law as one of the ways that we can cooperate, articulate what international law is, should be, new ways of thinking about it. Please join us both as participants in our events, but also as members of the commission if you are a lawyer. And I would like now to turn it over to Christina Voigt for closing.
Thank you, Cymie, and really thanks everyone, both here on the screen, online, and those who watched us today, for this very rich discussion. There is so much more to unpack. I think the questions showed it, and there is much more that we could have discussed, but we only had that 1 hour. But I think pushing forward is the right way to do, thinking about how to constructively implement the BBNJ agreement on a domestic scale is what matters now, as Cymie rightly said so. And to the last question about some states not wanting to engage, I think it just puts into perspective and contrast the many states out there that take these obligations seriously and constructively and cooperatively engage in the implementation and compliance with international law and the rule of law. Now, please let me thank our wonderful panelists today. I would also like to recognize Claudia de Windt as another recipient of the 2025 IUCN World Commission on Environmental Law Nick Robinson Award on Excellence in Environmental Law and Policy for her work of representing WCL before the Inter-American Court on Human Rights. Also, Professor Dr. Francesco Sindico for his work in representing us before the ICJ. So we had 3 recipients, and I just wanted to mention that. Many thanks, Cymie, for taking the initiative to have this important seminar. I can already see there's a follow-up to this in due course. And finally, please let me thank Roberto Cole, the WCL Executive Officer, who behind the scenes managed to have this fluent and smoothly webinar. Thanks, everyone. Until next time. Bye-bye.